Welcome to the fourth video in our Pro video series. In keeping with the same pattern, now we are at the video entitled The Amazing FCRA Case Examples. As always, I'm your course instructor, attorney Aaron Swift, the CEO and managing partner of Swift Law North. For an agenda, we're going to have a brief FCRA litigation timeline discussion. Then I will give bronze, silver, and gold case examples, much like I did for the FDCPA case example video. And then, as always, we end with some consumer best practices. Okay, so same disclaimer, every single case is different. Every plaintiff is different, every judge is different, every jury is different, every case and the exact facts are always different, except some class cases, but that's a little bit different. These this is supposed to be FCRA. Good catch. So ultimately, I can't give you an exact timeline. I can tell you the stages of an FCRA case are as follows. There's pre-suit stages that take a lot longer than even FDCPA cases because in almost every FCRA case, you're going to be disputing erroneous information, often several rounds of disputing, and each of those can take 30 to 45 days or longer if you don't get the proper responses. So the pre-suit stage of an FCRA case is longer, materially longer than an FDCPA case. And then again, it depends on the type of case afterwards. If it's bronze, it's not that long. Silver and gold, as the value increases, the length of a case generally increases. So, we're talking about 6 to 9 months, maybe a year on the short end for a bronze FCRA case. That's once it gets into litigation. Silver can be 18 months. Gold cases can take 2 years or more. But in those cases, it's definitely worth it considering the time value of what we're talking about here. So let's talk about some amazing case examples. Do the same classification system under the FCRA. We separate cases into bronze, silver, and gold classifications. That generally means bronze cases we think will only have statutory damages. It's a technical case, small value, usually a small timeline. Silver cases we think are going to have actual damages. And then the gold cases, we anticipate having punitive damages given the fact patterns in those. So let's talk about some amazing case examples. A bronze case, we had a furnisher who was reporting balances on discharged debts. It was 2 accounts that were clearly discharged in the bankruptcy. Even though they were bad accounts, we still disputed because they should not have been reporting with balances. A discharge is a discharge, and now that person's credit score was being impacted by not just the negative bankruptcy information, but also now by a debt to credit limit that was all thrown off and some other issues that were impacted. So it's definitely a case. It's not super sexy case. In the event where the consumer had just filed a bankruptcy, you're not going to have significant damages tied directly to just that issue. But nonetheless, it was still a case. And we filed, we got trade line deletions from all the credit reports. Even the pre-bankruptcy derogatory info, which could have absolutely maintained, we were able to get those deleted because of the dispute and the credit reporting and the lawsuit. And then on top of that, even though it was a bronze case, the consumer received $5,000 in his or her pocket. That's significant because that was more than double what he or she paid for the bankruptcy itself. Don't give too much details in these cases because of different publicity reasons, confidentiality reasons, privilege reasons. But for the most part, I can just say that he or she received in their pocket at the end of the day more money than he or she even spent on the bankruptcy itself. So that was a great, amazing bronze result. So now we have a silver case. This is a case where a consumer had settled a debt with a third-party junk debt buyer, even though it was in writing, even though the consumer had proof of the payment, the junk debt buyer was still reporting a balance, and so were all 3 of the major credit bureaus, the big 3. So after 3 disputes, the third of which went so far as to include every single document possible that should have led to the change in the credit reporting as showing no balance, as showing settled for less than full balance. They kept verifying, and they ended up getting sued. So as part of that lawsuit, because we had 4 defendants, there were some additional damages beyond just this settlement issue. There were some deletions that we could tie back to a debt to credit limit issue that shouldn't have existed. And that was a great result. So we got the debt deleted from all the credit reports, that finality, even the pre-settlement charge-off information went away. Excuse me. And then, of course, the defendants had to pay all the fees and costs. And in this case, the silver case, the consumer received $45,000 in his or her pocket. So imagine going from a scenario where you end up settling a debt, a charged off old debt that you owe or might owe to a junk debt buyer, to ultimately getting $45,000 in your pocket because the credit reporting shenanigans were so bad. And then lastly, let's switch to a gold, case example. So this is a case where a consumer was a victim of identity theft, and a major bank was reporting that they owed this debt. Even after so much proof was given that the consumer didn't make these fraudulent charges, um, even submitted a police report, identity theft affidavits, statements by a manager who was able to attest that the plaintiff was at work during the times the fraudulent charges were made somewhere else. Just so much information, and even went so far as to sue again in this case after so much evidence pointing to the contrary. Um, there were significant damages to the loss of a home. This was the only issue on this person's credit report. They had pristine credit otherwise. They 100% would have been approved for this house. Lost the contract, had to rent for a lot longer, rates shot through the roof, and it really seems significant damages non-economically too, with the stress of everything involved. So in this case, we definitely got the trade lines deleted. The consumer never owed them in the first place, but then we were able to put $500,000 in the consumer's pocket. So think about that, $500,000. Now, this person went through the ringer. They had awful experience, years and years and years of issues. It was a gold case, which a unicorn of a gold case, even at that, considering how clear the proof was, how clear the disputes were, how badly these companies just kept messing up, and the real significant true damages that we could tie directly to this issue. So, again, that's an amazing case example. It was life changing as we kind of turn to consumer best practices. Again, just understand you have rights. We stress disputing. Watch video number 10 for more information about what that looks like with our templates, and I walk you through how to use them and a lot of comments about how to use them. You want to be very intentional about how many things you apply for, review your inquiries often, because if you start to see things that look off, people checking your credit report that you didn't apply for, those could be early examples and early evidence of identity theft issues, which can be a gold case. So errors on your credit report, please reach out. Like I said, you could be entitled to significant damages like some of these amazing case examples. For more educational content, visit us at consumerlaw101.com. If you think you have a bronze, silver, or gold case, remember, we don't really differentiate. We differentiate, excuse me, but we don't distinguish necessarily or discriminate against smaller cases, I would say. We like helping consumers with small bronze issues all the way up to gold issues. So if you have any of them, please reach out to us at swiftlawnorth.com. We would love to help. And again, it's on the contingency fee basis. Thank you.